Lawyers of Reddit, what is a detail that your client failed to bring up to you that completely lost you the case? Opposing counsel, isn't it true you hit victim in the face with a brick? Client, no. Marcus hit him with the brick. I hit him in the back with a piece of wood. He'd sent a photo of his wife's bruised face to his wife with a message saying something along the lines of "This, do you want this to happen again?" He came across very well in court up to that point, but his mask slipped when that came out. A buddy of mine case as a public defender. A gal was busted on substance charges and told him she didn't have any substances on her when they arrested her. He thought, okay, we'll use that. Turns out, she didn't have any substances on her when they arrested her because she just sold them to an undercover cop. Custody case. Client failed to tell me he was previously convicted of felony child mistreatment for breaking 16 bones in an infant's body. Lawyer in the UK. I acted for a member of a famous child lover hunting group. My client was charged with various offences relating to his vigilantism, most seriously, causing grievous bodily harm with intent. He wanted me to fight the case on a public interest offence point that is not available to him in statute or at common law contrary to my advice. I followed his instructions as I'm bound to do. If the state won't punish child lovers properly, then it's left to men like my client to take the law into their own hands. A horseshit argument for a whole host of reasons. His laptop was seized by police and submitted for forensic examination. He had a staggeringly huge database of CP on it. He himself was a massive child lover. My house was robbed. In addition to all the stuff the thief took, he also stole a bunch of my suits and all of my neckties. I had a big collection, like 100 or so. However, the thief left fingerprints on a hard plastic box that I kept spare change in. Fast forward 3 months, the thief is caught in the act of robbing another house in the same neighborhood. Same detectives on my case and this new theft. They fingerprint the guy and the fingerprints match the ones from my house. At the thief's arraignment, I see him stroll in wearing my suit and my tie. I tell the district attorney. He says there's really no way to prove it. However, the tie he chose to wear was a one-of-kind street map of San Francisco, and I still had all the documentation to prove it. The district attorney's eyes widen, and he informs the judge. The judge has the thief placed under arrest again for possession of stolen property. The thief's lawyer was dumbfounded. It was a nice end to a rough situation. That he filmed his offenses for his YouTube channel. The cops didn't even know. A witness brought it up on day 3 of a trial. It was a nice quick change of plea that afternoon. So you're saying it's just a prank, bro? Isn't a valid legal defense? Not since Prankster v. Bro in 1986. Client said his ex owed him a lot of money and that she was trying to get out of paying him back by getting a protective order against him. Seemed reasonable, so I took his case. At the hearing it came out that they were never a couple, that he was sending adult toys to her residence on a weekly basis, and that she never asked for the thousands of dollars he gave her over the years. Stripper. We lost. He got laughed out of court and he learned a valuable lesson. Tell your lawyer the good and the bad stuff before trial. I'm a court-appointed attorney for qualifying individuals in family matters. Termination of parental rights case. Have been fighting to argue that parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic meds anymore, ready to be a parent, etc. After a few months of negotiating with all the parties and Department of Children, Court Services, we have a pre-trial to try and convince guardians. I meet with my client before the hearing to see if anything changed. Nope, all good, let's get my kids. Great, that's not happening today, but let's try. We get going in court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals 1. That no longer is working. 2. No longer in apartment. 3. Doesn't want to have a relationship with guardians despite her kids loving them. 4. Won't send her kids pictures of the toys they miss and can't have. 5. Plans on moving out of state. 6. Thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant. All in the matter of 15 seconds. I was too shocked to even react. Speechless. not the image of stability and parental fitness I've been trying to paint since last July. Edit to clarify, client was working really hard to get everything right and legitimately had everything going for her prior to this hearing. I was not making false representations or trying to get a monster reinstated. This was a true bombshell as I did my due diligence to make sure things were on the up and up and statutory requirements were met. Things fell apart very fast apparently. This was a very atypical situation. Parents typically do a really good job working hard to meet their requirements. Not my client, but the son of the opposing party, and presumably the party himself, lied about being blind to make himself seem more sympathetic as a witness. We didn't know either until he took the witness box. Their counsel asked him to take the oath, and he picked the card up and read it. That was the cherry on top of a series of ridiculous events. The judge dismissed the whole thing in our client's favor shortly after. I was a trainee at the time, but my boss, who was in her late 60s then, said it was the most ridiculous case she'd ever handled. And he picked the card up and read it. I was expecting he easily walked up or sat down, not that he was stupid enough to actually read something out. I wasn't a lawyer in this role, but was a law clerk. This was a typical divorce case. This particular jury trial was about splitting assets and who would get what. It was a long drawn out case that took about 5 days. Right before the closing arguments the attorneys wanted to talk to the judge. It seems as though a couple of days prior the couple decided to get back together, and instead of telling the judge and their lawyers, they just kept it a secret. We heard 4 days of evidence, arguments, brought in experts such as land assessors, financial planning people and the like, and they were back together. One of the attorneys asked to be dismissed from the case immediately and walked out the courtroom. The judge had to dismiss the jury and the couple was adamant that they didn't think that them getting back together was a detail any of their attorneys needed to know. Edit. Yes, in some states there are jury trials for divorces. However, this particular case wasn't for the divorce, but for a cause of action stemming from the divorce, marital property. It was a jury trial. I'm actually a lawyer, but I was only watching this trial, not participating. So the case was that woman A had hit woman B in the head with a heavy beer pint at a bar, and woman B got pretty serious injuries. The defense claimed that woman A had not hit anyone with the pint, but instead had just thrown the pint into a random direction, and it happened to hit B in the head. Thus it was an accident, and not a battery. Well, the prosecution had a CCTV tape from the bar, and it was shown at the trial. And the tape clearly showed in HD as A walked behind B and smashed the pint to her head so hard that the pint shattered on impact. I looked at the defense lawyer and his jaw literally almost hit the table. The prosecutor also noticed this and asked something along, thrown A. And the defense lawyer said that due to technical difficulties he couldn't get the CCTV tape open on his computer when he was reviewing the evidence. Woman A was found guilty. So yeah, I was completely dumbfounded. I can't get the file to play. What is it? Video of the incident. Oh, it'll show you didn't do it, right? Yeah. Great. Next file please. There's a rule you're supposed to follow when questioning trial witnesses, and that rule is to never ask a question you don't know the answer to. Despite this rule, lawyers often ask small, apparently inconsequential questions which are necessary to set the scene, but are so inconsequential or obvious that their answers are fairly presumed. This case was an exception to that general presumption. The defendant was arrested on a warrant and transported to jail. After booking him into jail, the officer returned to his vehicle and discovered a baggie of substance sitting right in the middle of the backseat. The defendant was charged with possession. At trial, the officer explained that he routinely searches his vehicle before his shift starts and after any time he transports someone in the backseat. The defense attorney tried to poke holes in the story, but the officer's testimony was remarkably consistent. The officer was fastidious about checking his vehicle. The appearance of the substance coincided with the defendant's presence in the vehicle. Then, as the defense attorney was running out of questions, he threw out the question, was there anyone else in the backseat of the vehicle? It was a Hail Mary. Even when there are multiple arrests, police tend not to transport more than one arrestee at a time, if they can help it. There was no reason to believe anyone else could have feasibly been in the backseat with the defendant. Though it's no surprise to you, the defense attorney and prosecutor were stunned when the answer came back as yes. Turns out, the defendant was with his girlfriend when he was arrested, and the officer courteously agreed to drive her to her apartment before taking her boyfriend to jail. This fact was not included in the police report. The officer never told the prosecutor, and, shockingly, the defendant never told his attorney. There was a palpable pause as this fact sunk in. Since there was another person in the back seat, there was more than enough reasonable doubt. Proofs were concluded, and the prosecutor threw out a half-hearted closing. The not guilty verdict was a given. Because of this case, I learned to never assume a fact, no matter how obvious it may seem. My father is a judge. I remember him talking about a case where a woman was suing for a severe back injury that she said was preventing her from working and taking care of her kids and so on. In the middle of the trial, a pen rolled off the table, and she is bending over trying to reach it from her chair, but pen was too far away, so she stands up and bends over and picks it up and goes back to her seat as if nothing is out of the ordinary. My dad is just looking at her, and she snaps at my dad and goes, "What are you staring at?" My dad asked her if she was okay, and her response was that she was fine. Her attorney leaned over and said something to her, and she then loudly started complaining about her back and how much her back hurt, but no one believed her. Lol. She snapped at the judge and said, "What are you staring at?" Employment case. We got to the deposition of my client and all set up. The first question is, "Please state your name." The client looks at me and says, "Can we take a break?" We do, and she pulls me out in the hall to tell me she's lied to me about her identity. She's apparently a serial fraudster and has changed identities 7 times since the 90s. She apparently thought the other returners had somehow figured it out, and that's why they asked the question. Now you put it that way, maybe I did hit the car. Simple is good. Not my case, which is a gift from above, really. Civil trial before a jury for injuries and prop damage from a MVA and punitive damages because defendant was intoxicated at the time of the accident. Let's call defendant DUI. Almost doesn't need to be said, but before DUI ever stepped foot in court, they would have been prepped repeatedly, first for the deposition and then for trial testimony with the standard questions. Were there any prior incidents, arrests/convictions, anything that can be used to impeach any of DUI's testimony, yada yada, over hours. Denies everything and is as clean as a clean whistle. Thus, at trial, defense counsel, DC, puts DUI on the stand to give them an opportunity to tell the jury of their contrition for this one-time error in judgment, describe the difficult time DUI was going through at the time, and otherwise show themselves to the jury as an upstanding member of society in order to reduce punitive damages. It goes well. Then plaintiff's counsel, PA, gets to cross. I'm going to paraphrase what allegedly happened next, which is purely hearsay. PA, earlier, you testified that this was a one-time mistake and you've learned your lesson. Is that correct? DUI, yes. PA, isn't it true that you've already been convicted of DUI in another state? DUI sits silent as DC immediately objects, but it's properly overruled, and DUI must answer. Since what happens next is impeachment, I'll skip the objections, but suffice to say they were being fired off as rapidly as a machine gun, and just as rapidly overruled. DUI, yes. PA, and isn't it true that, in your prior DUI, a child died? You can imagine what's happening in the courtroom, and, most importantly, amongst the jury. And you think it's over, stick a fork in DUI, it's done. But then, PA goes for the jugular. Do you remember the name of that little child that you annihilated while you were driving while intoxicated? Imo, this question is one for the ages, more powerful than the old when did you stop attacking your wife? Because no matter how you answer, and that is why you never ever lie to your attorney. I'm still a law student and this happened during my first internship at a court. A girl among other people was charged with substance possession, but because she had thrown away the substances and the police couldn't prove that she bought or owned the substances, we see it could have been one of the other people as well who still had drugs on them. The judge ruled in dubio pro reo. He then asked if she wants to say add something, and this girl asked if she can get her substances back. The defense attorney looked like he was about to get a heart attack. Edit. For those wondering, I know what indibio pro reo means, but I wasn't sure if they use the term in other countries and tried to explain it if not. This happened in Germany. Employment law matter. He claimed to have been unfairly dismissed over bogus performance management. The real reason, he organized via Craigslist to have someone collect a box of his discharge from a children's playground. There were explicit messages from him asking what they did with it and whether they rubbed it all over themselves. The employer provided us the messages. Edit. He was doing this on company time. Jesus, if you're going to be a creep, don't do it on company time/equipment. WTF is wrong with people? What is wrong with people? Broadly gestures at discharge box. Edit. Thanks for the gold kind strawards that. I have to smear the gold all over my body while telling you about it? No. A defendant was written a cell phone ticket while driving and defended himself. Your Honor, I was not using a smartphone while driving. I was actually using a flip phone. Guilty. I'm not a lawyer, and it's not even my stories but my dad's. He was working as a fraud investigator for an insurance company. I have a few stories of his, but here's 2 of them. Guy was claiming theft of multiple items, but mainly a ring. Things weren't adding up, so my dad and the insurance company's lawyer decided to do a depot of him. Guy shows up and is doing the depot when my dad notices the guy is wearing the exact ring he's claiming was stolen. My dad slides a note to the lawyer telling him the guy's wearing the ring. Once the note got slid, the guy realized what happened and put his hands under the table and took the ring off. They asked him to stand up, and lo and behold, the ring fell to the ground. Another one is a guy claiming a break-in and theft. Immediately things weren't adding up as the window was broken out instead of in. The guy submitted Polaroids of items he claimed were his, like TVs and such. Thing is, in the Polaroids you could see the reflection of the store they were in on the glass. He also claimed numerous CDs/records, but oddly enough every single one started with an R, S, or a T. We are talking hundreds of CDs/records. My dad was about to deny the claim in person, but noticed he had a gun on the table, so decided to do it over the phone. Ready for an escalation? Later this same guy was arrested for beheading a prostitute and throwing her head in the river. You've reached the end of this video, the Reddit gods, and I thank you. Please consider liking and subscribing for more top-notch content. Goodbye.